Makes a really important point here. The state wanting to make that clear, certainly, so that the proof can be made with a little bit less evidence there. Your thoughts on that, please?
First of all, it needs to be said that she explained it so well that I hope most law school professors were listening to that, because in my opinion, most of them are incompetent in being able to teach that, and usually can do it in 6 weeks. She did it in 6 minutes. So that's a sign of a high intellect and someone who studied well. In addition, here's another way that might help. When you argue these criminal statutes, these laws, these jury instructions, the game that's being played by both sides is that the government's trying to run the standard or bar down, and the defense, of course, is trying to run it up. That way, and you'll hear this in closings, they can argue the government prosecutor didn't meet their burden because it's a really, really high standard. Of course, the government will argue just the opposite. All right, let's be specific now on these facts in this trial. Why are they arguing about intent? Here's why. The defense has hung their hat on the following defense, and that is going to be the law says that the prosecutor must prove that before Officer Chauvin and George Floyd got together, the officer had it in his mind that he was going to contact Mr. Floyd and he was going to hurt him. He was going to do something to him that was so bad and so physically violent that it was likely, here's the law words, to lead to great bodily harm or something similar. That's a really high standard, and we all know they cannot prove that. And so they think they're going to get out on what most people refer to as a technicality or a loophole and say, they meet the burden, you got to set them free. What is the government arguing? They're saying, according to the wording of the law, which now has been interpreted by other courts and other judges, higher appellate court and Supreme Court above this judge, they have weighed in on those words of intent, and they have said that all you have to prove is that he had some intent to do something that was not right, that was illegal, but he did not have to form the intent to hurt him physically. It's enough to just touch him or to commit a crime without a pre-existing intent to hurt him. Now, let's put that in practicality. If you walk up to someone and you start arguing and all of a sudden that person trips and falls forward and you grab them and hold them, you stand them back up, technically you could call that a battery, which is an unwanted touching. That person say, you committed a crime. Another way to look at it is if two people get in an argument, the other one steps back and says something and boom, hits them in the face. Okay, that's a battery too, and if you hit them hard enough, you created some damage. Now you have a physical injury, which is a greater intent, or if you will, a worse intent than just catching someone or laying your hands on them and having no intent to hurt them. Why is the intent so important? One shows a more depraved heart or a willingness to commit a crime than the other. One's a higher standard than the other. And there's where the argument is, and I think the defense is going to lose on this because of the case law and the other cases that come before saying that it is enough. If Chauvin intentionally put his hands on Mr. Floyd, whether or not that would have resulted in an injury and whether or not he thought it would is irrelevant. He intended to put his hands on him. That's all the government has to show. And as a result, this murder charge now can be viewed and judged by the jury. There is the big fight.
Joseph Lowe, thank you. We are out of time for this segment. We're going to take a break. When we come back, we're going to continue our live coverage and legal analysis here on Court TV.